Hi there. Welcome to the Employment Law Show. Good to have you along for the next half hour. My name's John Scholes. Joining me momentarily from employmentlawyer.ca, Lior Samfiru. He's the boss. You want to reach out to Lior anytime. Make that phone call. It's always a good chat to have. In fact, it's necessary in many circumstances. And that number, 1-855-821-5900. You can email to go along with that. help@employmentlawyer.ca. We'll get to some other contact information and websites that are going to be useful for you ongoing throughout the half hour. But we also have a main topic every week. This is all about parental leave, taking parental leave. We'll get to that later on in the show. Some phone calls from our radio shows across the country and a whole bag of good stuff to educate you and involve you in the show as well. This crazy world of employment law and workplace rights. We'll get to all that. But first, Lior, welcome to the show, pal. Good to see you back again this week. We always get warmed up, kick things off with the case of the day. What do you got going on for now?
Great to be here, of course, John. I'm one of those guys who enjoys talking about employment law. It's kind of the thing that I do. It's my way of communicating important information to everyone out there. You have a right to know about your workplace rights. Maybe your employer doesn't want you to know some things. Sometimes employers may hope that employees may be a bit ignorant to their rights, and unfortunately, a lot of people are. Not if you watch this show, not if you listen to John and I on radio. Then you have a lot of knowledge, you understand your rights, and you make sure that the law does for you what it's supposed to do for you, protect you and allow you to work in a healthy and supportive work environment. It's not always going to be sunshine and rainbows at work. Sometimes we're going to deal with issues or a bad boss or a difficult situation, or maybe we lose our job unexpectedly. In all those situations and much more, we have rights. There are laws that have been created that protect us. I've said this before, but it bears repeating. Right here, we have some of the best employment laws in the world. So you don't believe me? Ask me the question. You can ask it, of course, always by connecting with me through email, through phone. We'll give you that contact information throughout the show so we can have a private chat and I can prove to you that your rights are quite comprehensive. But to start us off, let me give you an example of a situation that came across my desk over the past few days. I spoke with a lady who is the primary caregiver for her very elderly mother. Unfortunately, very recently, her mother had taken ill, and she was required to be there with her to provide care pretty much around the clock, at least for a period of time until other arrangements could be made. She spoke to her employer, and her employer said, "That's fine, we understand. Take that leave of absence." Well, wouldn't you know it, 2 weeks or so into that leave, her employer says, "Unfortunately, we cannot extend that leave. If you can't come back to work, we have no choice but to let you go." Obviously, this employee was very upset. She contacts me and she wants to understand what her rights are. So the thing is this: certain leaves are job protected leaves. This is one of them. We call this family caregiver leave. You have a right to take the job-protected leave of absence from your work and to care for, in this case, a parent, and you cannot be let go. Your job is protected, very much like a parental leave, which we'll talk about later. You can't be let go during a parental leave. You cannot be let go during a family caregiver leave. So in this case, because she was let go, we call this a reprisal. She's getting punished for pursuing her rights. It could be a human rights violation. It could be an employment standards violation, a wrongful dismissal. It's illegal. So remember, there are certain leaves of absence that the company must give you, and your job is protected. And if anything happens to you in that case, it's going to be illegal. You have to call me because you may have very significant entitlements.
As far as that particular leave is concerned, Lior, does an employer have any leeway as far as time limit? 6 months, 2 years, 5 years, or it's as long as the employee needs?
So in Ontario, for example, the family caregiver leave is 8 weeks. So your job must be protected for 8 weeks. In some cases, that could be extended, etc. But at a minimum for 8 weeks, your job is there. You cannot be let go. In this case, she was let go after 2 weeks. Guess what? Completely illegal. Employers shouldn't have done that. There's going to be repercussions. When you break the law comes back and says, well, now there's repercussions.
Is there legally other things that can be done? I mean, you could switch it back to the employee saying, my mom's still not well yet. It's going to be a few more weeks or months. How about I work from home, for instance? Can there be accommodation that way? And does the employer have to, bend to that?
Well, yeah, under human rights laws, we have the right to be accommodated based on what we call family status. and that includes being in a parent-child relationship. So if you need to be accommodated because of your child or because of your parent and your employer doesn't provide that accommodation, well, that's a human rights violation. They must accommodate. So maybe you need time off, or you need some flexibility in your work hours so that you can care for your family. That employer must do everything to make that happen. And if they don't, that's a very, very big deal. That usually happens when it comes to childcare issues. I need to be able to leave early because I have to pick up my child, etc. But it can also happen with respect to a parent that you care for. So yes, again, just another example of how the laws that we have from several sources protect you and give you rights.
In addition to joining us weekly here on this TV show, we love our viewers. Thank you so much for spending the half hour with us. If you can do the entire thing every week, that's great. Beyond that, you can catch one of our radio shows. Lior and I and his team have been doing this for years and years. Stations across the country, employmentlawyer.ca. You want to search out a station near you. And always encourage not only to listen to the radio show, but participate. Pick up a phone, call us, ask your questions. We'll get to 2 or 3 of them during this half hour. First one, Lior, from a radio show is coming up right now. Have a listen.
I basically have been working for a firm for 2.5 years, 64 years old. The company moved me to another location within the city. It was a lot more driving. It stressed me out, and I've had some health conditions. My doctors ordered me to work 4 days a week. Some months later, they want to basically terminate. They're not offering me a lot, so...
What are they offering you?
6 weeks.
Wow, what do you think about that?
Well, there's a few things here, obviously. If this person has a medical condition that requires accommodation, either the ability to work from home or reduced hours or certain number of days in the office and certain number of days at home, that is an accommodation that the employer must provide, okay? It's not up to the employer. Under human rights laws, if there's a medical condition and that's supported by a doctor's note, that employer has to find a way to accommodate. They can't say, that's too hard, so we're going to let you go, or it's too hard, we're just going to refuse. No, you have to be accommodated. Modified hours, modified duties, working from home. All that is fair game and something an employer must do. So right off the bat, we have a human rights violation. But that wasn't enough for this employer. They want to go the wrongful dismissal route as well. The question now becomes, is the 6-week severance offered adequate? Spoiler alert, it's not. But I'm going to show you how you can find out for yourself that it's not. We're going to use their severance calculator tool. You can find that at pocketemploymentlawyer.ca. Let's use that calculator right now and see what the right amount of severance would have been. So we know that this person in a professional role after 2.5 years of service and at the age of 64 was offered 6-week severance. Except we see right there at the bottom what they're actually legally owed is 6 months of severance. So the 6 is fine, except it's months, not weeks. And yes, short service employee after 2 years of service is going to be owed that much. You can use the severance calculator yourself. Again, pocketemploymentlawyer.ca. It's free and anonymous. Make it the very first place you go to if you lost your job and want to understand what you're owed.
You know, it's a really good phone call. There are lots of interesting pieces in there and a couple questions. As far as the medical condition is concerned and the employer, how far can they poke around as far as what's wrong with you, how long you need to be off? Where do you draw the line as far as the employer, what they're allowed to know?
Well, think about this for a second. If you have a medical condition that requires you to be off work, does it matter if it's depression or a herniated disc? It doesn't matter. What matters is your ability to work. Everything else is private, it's personal. So your employer doesn't have the ability to demand to know that. Your employer cannot ask and demand information about the particulars of your condition, about your treatment, about the types of doctors that you're seeing. All of that is, number one, irrelevant, but it's also private. What your employer can find out is, can you work or can you not work? How long are you going to be off? What kind of an accommodation could they provide you to allow you to work? Those are legitimate questions, and you should provide that information from your doctor. But anything that goes into the personal aspects of your condition, that's offside, and you should not be required to provide that information.
This caller also mentioned quickly, Lior, relocation and longer commute. How does that piece work into it?
So obviously, if you're being told you have to go further to work, that's a big deal now. So generally speaking, I look at an hour threshold. If the new commute, the new location is going to require more than an hour to get home or to get to work, that is now constructive dismissal territory. If you're now going to be traveling an extra hour in the morning and in the afternoon, you may be able to say, not okay, I'm not accepting that. That is a significant change in terms of my employment. That's a constructive dismissal, meaning you can get severance. Now, if it's a minor move, it's only 25 minutes, it may not make you happy, and I get that, but legally, that probably would not rise to the level of constructive dismissal.
All right, that was a great phone call. Let's see if number 2 yields as many good things. It's coming right now, Lior. Listen up.
Last year, I was given the opportunity to sign a new contract. I'm an employee of about just over 10 years. At that time, I chose not to sign a paragraph regarding severance, limiting my severance to 3 weeks per year. So in lieu of that change to the contract, they are giving a new RSP contribution. I don't know what I should do.
Take it away, pal. What do you think?
Well, here's the thing. I mean, by not signing the contract, you may be losing something that the contract would provide, but you may be gaining something else. You could have a contract that you sign that could cost you tens of thousands, even hundreds of thousands of dollars in future severance. So that may be worse than getting some other benefit. Now, without knowing what the contract says or does, I really can't say more. So what I would ask her to do is to send me a copy of that employment agreement. Let me review it, and we'll talk about pros and cons. But generally speaking, here's what you have to know. If you're an existing employee, you've been working for the company, and the company comes to you, knocks on the door and says, hey, we have this new agreement for you to sign, that's not good. That's bad news for the employee. I can almost guarantee you that in that employment agreement, there are going to be terms that cost you money, that take away rights, like the ability to get full severance, like giving the company the right to change your job, change your pay, change your hours. So never, ever sign that employment agreement without seeing me first or having me review it so that you know exactly what you're agreeing to.
All right, we'll take a short pause, get to phone call number 3, and our main topic on the other side of that break. We're going to be talking parental leave. All about that topic is on the way as we continue. Phone number in the meantime for Lior, 1-855-821-5900, or email, or in addition to the email, help@employmentlawyer.ca. Lots more of the Employment Law Show is just ahead. Don't go anywhere. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, we are back at it. Lots more of the Employment Law Show is right here, right now, so let's get into it. EmploymentLawyer.ca, that's where you want to go to find a radio station in your community close to you that you can tune into and catch our weekly shows. We get the phone calls from them, the good ones. We cherry pick them, play them back here because they're always informative and educational. This will be the 3rd phone call for this show, Lior, so let's listen up and get to it.
Well, this question's for a friend of mine. He got a CEO job about 1.5 years ago, but once he got into the job, he found that the atmosphere was really toxic. Like the founder, she'd belittle him, micromanage him, and swears in front of his colleagues at him, and now he's had it, and he's got stress. Like, he's looking to take medical leave, or should he just resign and say that's constructive dismissal?
Which is the correct way to go, Lior? What do you think?
To work in a healthy work environment. We should never be harassed, belittled, mistreated, bullied in the workplace. Unacceptable, and that's why we have laws to protect that. Now, usually I would say to this person, speak to someone and file a harassment complaint. That's not really going to be possible here. It's the founder of the company that's harassing him. So who is he going to complain to? There's no one above the founder of the company. So the question here is, can we prove harassment? remember, the boss, the founder, is not going to admit it. So I would tell this person, let's find a way to document. Write things down, record things, send someone an email confirming what happened. Do that contemporaneously. Once you have that proof, that can absolutely be a constructive dismissal. Once you can show and prove that you've been bullied, harassed, mistreated, we can get you out of there with compensation. Absolutely. So no, don't just resign until we have the goods, until we have the proof. So the fact that you know you've been harassed and it's happened often doesn't mean that you necessarily can prove it. Again, it becomes a he said, she said. Document, document, document. And if you do that, it's easy to deal with. Don't just suffer. If you go off on a stress leave, you're going to come back to the same environment. That's not going to really make any sense. So let's get the proof, and then let's pursue a constructive dismissal. Let's get you your full severance so you can move on to a place that treats you better.
Again, got to thank you for making those phone calls into the radio shows over the last couple of weeks. We really appreciate them coming. Keep them coming when you join us on air. Employmentlawyer.ca to find a station near you. Okay, main topic is maternity leave, paternity leave, parental leave. Let's get into this, Lior. First question. Do you have to inform your employer if you're expecting? If so, how much leeway do you got to give them, or do you have to tell them at all?
So the reality is no, there's no legal obligation to tell them once you're expecting, okay? And oftentimes people have different views on that. Some people want to tell their employer as soon as possible. Other people want to wait a while. Both are fine. Keep in mind, you cannot be punished in any way because you're expecting, because you're about to take a leave. So it really is up to you when you're comfortable telling your employer. Certainly, if you're going to be taking a parental leave, you're going to have to tell your employer at some point about that, for sure. But you may be able to wait if you want till later on. Maybe at some point, if you're a mother, you start showing and it becomes a bit of a moot point. But you don't have to tell them, and I'll extend that. Let's say you're interviewing for a job and you're pregnant. You don't have to tell this new prospective employer that you're pregnant and you're expecting at some point. Not at all. That's private, that's personal, and that the fact that you're pregnant should not have any impact on the decision to hire you or not hire you. So it's completely up to the employee that's pregnant or the father that's going to take a parental leave. You don't have to tell your employer a year in advance. I think giving notice is a good idea so that your employer can make arrangements while you're off work, but it's up to the employee completely.
Let me ask you this question, Lior. So you're off on parental leave, which, by the way, I mean, I know in Ontario and other provinces, generally across the country, parental leave is pretty robust. You're off for a while, but that's going to leave a void, a deficit for your employer. Can they hire someone to replace you, fill in your position until the leave is over?
Absolutely. Your employer is allowed to run its business. So if they need to bring someone in to fill in the role that you were doing, absolutely they can do that. So they can hire someone, they can reallocate resources and have someone in that role. There's no issue with that. But despite that, you still have a job when you're back. So if they brought in someone to do your job, that person can't remain in that role once you're back from parental leave. Your employer can't say to you, oh, we like that other person better, so we're keeping them in that role. That's not legal. You have to be taken back to the same job. But while you're off, whether it's 6 months, a year and a half, yes, your employer can have whoever it wants filling in that role, but that's only temporary. No ability to say that's permanent. As long as you want that job, it's yours.
How does termination work during a parental leave, Lior? I mean, can they do that, let you go at all, or your job is protected, as you always say?
Your job is protected. It's why we call it job protected leave, meaning you're not allowed to be let go while you're on parental leave. Now, there's an exception to that. And the exception is if the termination had absolutely nothing to do with the leave. In other words, if it would have happened exactly the same way, even if you were still working. I'll give you an example. So let's say you go on a leave, everything is fine, but then a couple of months in, the company decides to shut down the department and let everyone go from that department. Well, if you're working in that department, they may be able to let you go as well because they're not picking on you. It's not because of your leave. It's simply a business decision that happened independently of your leave. Now, that's very narrow, and that's only in very limited circumstances. In most cases, if your employer lets you go while you're on a leave, that could be a human rights violation, an employment standards violation. It's not legal. So in some narrow set of circumstances, when it's unrelated and they can prove, the employer has to prove that, It's unrelated to the leave. Yeah, maybe there's some leeway. Otherwise, if you lose your job, you call me. By the way, you always call me if you lose your job in that situation, because if you're on a leave and you're let go, you're going to be owed even more severance because, again, it's going to take you longer to find another job. So you have to consider that.
Can your employer make changes to that job when you come back?
Generally speaking, no. You have to be brought back to the same job, same responsibilities, same pay, same hours, same everything. So an employer cannot make those changes. The job, the way it existed when you left it, must still be there for you when you come back to work. Now, beyond that, I'll even say that if in the meantime that job increased the pay that it pays people doing it, well, when you come back, you have to get that increased pay. You cannot be told, well, everyone else got a pay raise. You didn't because you're on a leave. That's illegal. Now, of course, if there's a big restructuring that happened while you're gone and the job has changed significantly, that's different. But otherwise, your job has to be there as you left it. Your employer can't say, well, we're going to have someone else do your job. We're going to just put you in a different role. No. Again, employment standards violation, human rights violation, constructive dismissal, not legal. It's quite simple. You have to be brought back to the same job, same pay that you had before the leave.
Kind of as you mentioned before, Lior, I'll ask you one more question. If you come back or plan to come back in your position, your job no longer exists for one of the reasons you mentioned, what are your legal options? Is there severance involved, enhanced, less? How does that work?
Obviously, the rule applies here as well, that if you had a job and lost it, you are owed severance. But this is a bit more interesting than that, because if you lose your job coming back from a parental leave, there's potentially other legal violations that have happened. As I said, human rights, employment standards. So you may be owed additional compensation beyond just your severance. In fact, that additional compensation can be more than the severance that you're owed. So whereas in a normal termination situation, we'll simply consider severance. What are you owed for severance? Make sure you get that severance. When you're let go coming back from a parental leave, there's other consideration that means you're owed more compensation. So it becomes that much more important to call me in that situation. You always should call me if you lose your job. It's even that much more important if you're a parent that took a parental leave and find out now you have no job.
Okay, we'll take a short break here, Lior, so stand by. We'll get to one of your questions from the live stream, an email question, and still to come, the Employment Law Rapid Fire to wrap up the show. That is all on the way. If you want to reach out to Lior, you can do so anytime, 1-855-821-5900, and help@employmentlawyer.ca. More of the Employment Law Show is just ahead. Don't go anywhere. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And we are back at it. Last few minutes to go here in the Employment Law Show. We want to get to a question, Lior, from your live stream, which you and your other lawyers host during the week. YouTube, Facebook, LinkedIn. You want to join at stlawyers.ca, at stlawyers.ca. For this week, I was put on a temporary layoff a few weeks ago. Do I have to accept this and wait for them to call me back? I've been with the company for almost 5 years, and this has never happened before. I'm 55 and earn a salary of $62,000 a year in a supervisor position. Take it away, Lior. What do you think?
No, in most cases, you do not have to accept a temporary layoff. By putting you on a temporary layoff, you may have the right to consider your employment as being terminated and require your employer to pay you severance. So no, there is no right for most people to be put on a temporary layoff, especially if it happens for the first time. So this person, having been put on a temporary layoff for the first time, can get severance. Question, of course, always, well, how much severance is he owed? Well, let's go to the severance calculator once more. We'll find that at pocketemploymentlawyer.ca. Let's plug the information and let's see how much severance. So we know that this person has been there for 4 years, 55 years of age as a supervisor. Company hasn't paid severance, but they owe severance. We see at the bottom there, he's owed 8 to 9 months, or probably around 8 months of severance is probably the right amount after 4 years. So kind of 2 months per year. That's what he's owed. Same with you at home. You can use the severance calculator anytime you want to find out what your rights are.
All right, another question here, Lior. This one comes from terminationquestions.com. You can use that freely and anonymously, of course, anytime you want. Terminationquestions.com. Here it is. My boss originally placed me on a 6-month probation period when I was hired. Recently, I was given a last-minute project that I wasn't prepared for as we become increasingly understaffed. Now I'm being told my probation is being extended because of performance concerns. Is this legal?
So this person's not on probation. That's nonsense, okay? You can really only be on probation for the first 3 months. That means that if this person is let go now, they're going to have to get their severance. Now, what I'd be more concerned about is the company saying, you had all these performance issues, so we're going to let you go for cause. What I would tell this person is this: if you think that these performance concerns are not justified, or maybe there's extenuating circumstances, I want you to send an email to your employer and tell them in writing, employer, here's why my performance wasn't what you say it was, or here's other information that you have. Send that in writing. By doing that, you're going to make it very difficult for the company to let you go. There's no such thing as randomly being put on probation. It's meaningless. My job was going to be to ensure that if this person is let go, they get their full severance and the company doesn't even think to avoid paying them what they're owed.
All right, a couple of great questions there. We appreciate you sending those in. It is time for Employment Law Rapid Fire. Here we go. Okay, Lior in the hot seat once again. First question for this week, Rapid Fire. Can an employee take sick leave without a doctor's note?
If you're going to be gone from work for a more extended period of time beyond a couple of days, yes, you do need a doctor's note. Your employer can insist on that. So it may take you a few days to get into your employer, to see that employer, get that note. That's okay. But once you have that note, you can be off as long as needed. Very, very good idea to go ahead and do that.
All right, rapid fire question number 2. Can an employee accept a temporary reduction in pay?
Well, I guess the real question is not can they, but should they? And the answer is probably not. You shouldn't. If you accept a temporary reduction in pay, you may be giving the company the right to do it again and again, and that's not something you want to do. The better option may be to say that's a constructive dismissal. Of course, it's not every reduction in pay that's a constructive dismissal. So if your pay has been reduced, before you do anything, call me so we can discuss all your options.
Okay, Lior, number 3. Can an employee still get severance after being fired for cause?
In most cases, John, a termination for cause is not really a termination for cause. The employer pulls the trigger on a cause termination before they should. It's very difficult to terminate for cause. So what do I see in the majority of cases? When the company lets the person go for cause, it's not really cause. Therefore, severance is owed. You can only be let go for cause if you've done something terrible.
All right, next question, rapid fire. Can an employee negotiate for a larger severance package?
Well, an employee, in theory, could do this on their own, but in most cases, it's just not possible. An employee may not know what to ask for, why they're owed more, and they're not going to be taken seriously by their employer. That's where we come in. Our name on that letterhead makes all the difference. We can get this resolved. We do this for a living. So no, I do not recommend trying to negotiate severance on your own. Call us and let us do our job.
All right, we got it all done. That's it for this week. Thank you, Lior, so much. Thank you for tuning in. Call them now anytime, 1-855-821-5900. Email help@employmentlawyer.ca, and always with the website, pocketemploymentlawyer.ca as well. It's been a pleasure. Thank you so much. We'll do it all again next week right here on the Employment Law Show. Thank you.